Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts, and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA, or Latin America to learn how to manage your IP assets and expand your business successfully.
Good morning, Europe, and good afternoon to Southeast Asia. Welcome to our webinar organized by the Southeast Asia IP SME Helpdesk, the Portuguese Chamber of Commerce in Vietnam, and AVCO Legal. My name is Nora. I'm the project manager of the Southeast Asia IP SME Helpdesk, and I will be today's webinar moderator. Before we get started, let me just quickly go through the housekeeping rules. So today's webinar is recorded. So we also look forward to an interactive session. So if you have any questions or comments, feel free to use the question box and send us the questions. So we will answer at the end of the webinar during the Q&A. And we will also have some poll questions for you. So we encourage you to use the poll feature so we can hear your opinion about the topic. So today the agenda for today's webinar will be a quick introduction from me on the Southeast Asia IP SME Helpdesk project. Afterwards, Sergio from the Portuguese Chamber of Commerce will give you an introduction about the chamber and some welcome remarks. After, we will continue with Antonio Vinal's presentation from AVCO Legal, how to set up a company and about tax incentives. And then Jeannie Wong, external experts of the Southeast Asia IP SME Helpdesk, will continue with a presentation on how to protect your IP in Malaysia. And then we will close with a Q&A session. So very briefly about the Southeast Asia IP SME Helpdesk. It's an initiative of the European Commission to support EU SMEs with intellectual property rights services in relation to Southeast Asia. All services we offer are free of charge. A quick snapshot about our services. So we have an inquiry helpline where we can advise SMEs one-to-one on any IP question they have on the region. On our website, you can find a lot of information about different IP topics and different IP tools. You are welcome to join our trainings throughout the year in Southeast Asia or in Europe, or like today one online, to learn about IP. We also have recordings, so if you cannot make it for the session, you can always access the recording, which is also uploaded to our website or YouTube channel. And last but not least, we have a wide range of publication available on the website. So we have an IP fact sheet for all 10 ASEAN countries and IP-specific guides related to different topics. So that's all from us. So now we can dive into the presentation of our speaker. So with that, I would like to give the floor to our first speaker, Sergio. So over to you.
Thank you very much, Nora. Good morning and good afternoon. My name is Sergio Silva. I'm the chairman of the Portuguese Chamber of Commerce in Vietnam. Today we combine the two best things that we have in our business community. He's the IP Helpdesk that is based in Vietnam, with leading from Nora and his team. Thank you very much to support us. And also Mr. Antonio Vinal from AVCO, one of the most prominent law office in Portugal, which is our member and very active member to support another members to establish the business in Portugal, in Vietnam, and also in Malaysia. Why Malaysia? Malaysia, because it's a member of ASEAN, make all sense that this market is important for the Portuguese business based in Vietnam or based in Portugal as well. And also Malaysia is quite similar market as Vietnam, and makes sense for Portuguese to extend his business in this country. So I will not take more time, since the most important is to listen to the experts in this webinar. I would say again, thank you very much for Nora's team, and also Mr. Antonio Vinal to make this webinar so insightful. So thank you very much and hope to enjoy. Have a good afternoon or a good morning for you.
Thank you very much, Sergio. So we will then continue with Antonio. So please share your slides, Antonio.
Will do. Thank you very much, Nora. Thank you very much, Sergio, for your kind introduction. And I will begin my presentation. Of course, the topic we have today in hand is extremely vast. Nevertheless, I will try to concentrate in 15 minutes as much information as I can. And well, as Sergio mentioned, we have at AVCO Legal are present in Malaysia. We have been present through our rep office initially, and our current company, AVCO Corporate Services, and we are a corporate services provider in Malaysia. We have assisted many Spanish, Portuguese companies and other EU companies in their process of doing business in Malaysia. And I would like to share some of the most relevant tips and procedures that any company will have to face whilst doing business in Malaysia. So without further ado, the topics for today's presentation are, well, how to set up, initially from least complicated setup to the most complicated setup. So we will start with the representative office and regional office, moving through branch and subsidiary, take a brief look at taxes as well, incentives. There's a plethora of incentives to be considered, and therefore I shall just pinpoint the resources where we can actually obtain more information that might be more relevant for industry. and of course the employment pass for those who were non-Malaysian and would like naturally to establish themselves on a personal level in Malaysia. In terms of the setup itself, as I had mentioned just now, we'll be moving from the easiest, least complicated setup to the more elaborate ones. Regional office or a representative office is the place where you would normally start. That's what we did when we first entered Malaysia back in 2014. And therefore, we need to establish a main difference between these kind of offices and a branch or a subsidiary. And here we cannot develop, we cannot perform any commercial activity. Okay, so the allowed activities as shown on screen are essentially those that might help us have a presence, establish a presence in Malaysia, assist our parent company in their transactions or dealings with the Malaysian market, but we cannot we cannot perform any commercial activity. And that might also include leasing warehouses, entering any sorts of contracts, or providing a service in exchange for a fee. Okay. So it is very helpful, especially when we first approach the market on a commercial level. Requirements are very simple. We just need to show that there will be a minimum annual expenditure of 300,000 ringgit. Naturally, the funds must come from outside of Malaysia, and the license can be granted for a maximum of 5 years. So initially, it would be for a shorter period, maybe 2 to 3 years. Eventually, we can apply for an extension. Once we've reached those 5 years, then we would have to think about any other kind of setup that would allow us to continue with our presence in the country. In terms of performing an actual commercial activity, we would have two options. Option number one is a branch, whereby we simply incorporate an extension of our parent company. Let's say it's a Vietnamese company or a Portuguese company that wish to establish a branch. It is not an independent entity. It fully depends on the parent company. That's why it has no minimum share capital. And that is also why the parent company is liable for the branch obligations. Okay. And in terms of requirements, we need to factor in at least one resident representative of branch. Nationality is not important as long as that representative is a legal resident in the country. Subsidiary, here we are looking at a fully fledged Malaysian company incorporated as per Malaysian law, the Companies Act of 2016. Very simple procedures. Actually, the Companies Act of 2016, which repealed the previous legislation on the matter, simplified to a great extent the procedures and the internal workings of companies. And as you can see on screen, minimum share capital is just 1 ringgit. You only need one shareholder and then one director, who has to be resident, independent of nationality. And yes, one corporate secretary, also resident, is mandatory as well. Moving on into taxes, well, of course, as we saw just earlier, a representative office or a regional office do not perform any commercial activities. Therefore, they do not generate income, and therefore there's no corporate income tax to be considered. Branches and subsidiaries do share the same rate, which is 24%. And there is no GST or reduced rate GST, goods and services tax, and there's a reduced rate, 0%, and a normal rate at 6%. one thing to take into account, especially for Portuguese companies would be willing to enter the Malaysian market, is that there is no double taxation treaty between Malaysia and Portugal, and therefore we would have to revert to the internal rules of Malaysian tax codes. Looking into incentives, there are two potential categories, and we would need to consider which one is more suited or best adapted, because they are non-cumulative. Okay, so either we look into the so-called pioneer status, whereby we can find tax exemptions for a period ranging between 5 to 10 years, or we can opt for the investment tax allowance, which is based on capital expenditure. So obviously, if there is going to be a lot of acquisition or machinery or property, plants, construction of plants, etc., all of that would be eligible. And the place to go to, your first port of call, would be MIDA. That's the Malaysian Agency for Investment. And as I mentioned at the start of my presentation, you would find with MIDA a plethora of different industry-specific incentives. So that would be your first port of call, which I highly recommend. And then depending on the state in Malaysia where you would like to settle your business in, then your second port of call would also be state authorities and state agencies that might also provide further support. And if we look at the Kuala Lumpur region, the capital of Malaysia, then we would revert to Invest KL, which is the main agency serving the Kuala Lumpur greater region. If we're looking into securing an employment pass, and this is, of course, relevant for the purpose of engaging foreign employees, or if you want, as we've seen, to hire a foreign representative that would be working in Malaysia, that person would have to obtain an employment pass. So obviously that employment pass would allow the person to become a legal resident in Malaysia. Nevertheless, there are requirements in terms of minimum share capital. So depending on the equity within the company, our minimum paid up capital would be a little higher or lower. So if we look at an 100% locally owned company, the minimum paid up capital, it becomes 250,000 euro. If it's a joint venture where foreign equity represents 30% or lower, then the minimum paid up capital increases to 350. 100% foreign owned company is possible, but then we're looking at a minimum paid up capital of 500,000. And those companies, foreign owned, operated in wholesale, retail, and trade, would see that paid up capital increase to 1 million. Again, the registered office and representative office, the representative office and regional office can also hire foreign representatives, but the number would depend on the activities performed and the merits. So essentially, of course, the representative office does not have any paid up capital, and therefore, again, the legislation does allow for hiring, but the number would depend on the activities performed. Then moving on, if I can move on. Just a very brief presentation on our firm. We have offices in Spain, Portugal, Italy, and Malaysia. In Malaysia, we're present through AVCO Corporate Services, as I mentioned right at the beginning. Of course, we assist with cross-border transactions, Portugal, ASEAN, and very much focused on company setups, tax, employment, looking into incentives, commercial agreements, and dispute resolution, legal aspects from the Portuguese side, and also the corporate service provision of services in Malaysia. And that, of course, that's where the whole incorporation and accounting, etc., takes place. Industries that we have been working with or engaged with, ranging from fashion, tourism, IT, wineries, and so forth. With regard to individuals, of course, as we have seen, a very important factor is immigration. And for many of them, of course, real estate and taxation of their salaries in Malaysia. Also do ask for business guides relating to Spain, Portugal, or ASEAN. So do reach out to us, feel free. And well, thank you very much for your wonderful patience and your kind invitation by IP, Southeast Asia IP, and the Portuguese Chamber of Commerce in Vietnam. I'll be happy to take any questions after the remaining presentations. Thank you very much.
Thank you very much, Antonio, for the very concise presentation. It was straight to the point. Now let's continue with Jeannie to share us a bit more on what companies should know to make sure that they land on the Malaysian market in a safe way. So I already see your presentation, Jenny.
Thank you so much.
Yeah.
It's on the slide. Yeah, thank you so much. Good morning to those dialing in from Europe, and good afternoon to those calling in within Southeast Asia or Asia. I'd like to thank Nora and her team, and as Southeast Asia IP SME Helpdesk for this opportunity. I will dive straight into the agenda without going into my bio. Basically, I'm a legal practitioner in Malaysia. Today, my presentation will cover a wide-ranging topics from an introduction to intellectual property rights, the reasons for a company to protect its IPR, what are the main types of intellectual property rights. And I'm sure there are so many others. It's just that due to the time constraint, we can only focus on a few key IPRs. And what are the applicable laws in Malaysia? How does one protect the IPR in Malaysia, and what you really need to know in practical sense? And in summary, what are the key takeaways? And we'll have a couple of poll questions towards the end, just to test whether you are paying attention or otherwise. As an introduction, the common question is, what is intellectual property? Well, it is a type of intangible asset created by human intellect. It is always referred to as the creations of the mind. And as the name suggests, intangible in nature. So intellectual property rights are intangible in nature. And when you compare with the tangible assets, such as buildings, equipment, your property, your land, your buildings, they are intangible. And usually they would refer to innovation, to human capital or human resources, your organization structure, your system, like what a franchise system would be. And you need to convert these intangible assets into something, that are protectable by way of intellectual property rights. And there is no exhaustive definition of IP. It is always evolving with advances in science and technology. And now we're talking about ChatGPT, NFT. There's so many new areas, emerging areas every day, right? Well, we need to go back to basic, right? And the starting point is we'll refer to inventions. We'll talk about rights protecting designs, brands, and creative works. And intellectual property being one of the asset classes, it can be dealt with or exploited in many ways, like tangible assets, like your property, like your house, like your land. It can be sold, it can be bought, it can be licensed, it can be exchanged, it can be transferred under will, and it can be negotiated for other benefits. So then it comes back to the fundamental cushions, because when you find out about the cost of protecting, for example, patents, it may be quite expensive. So there will be some reasons, justifications for you to talk to your management or your CEO why there is a need to protect your intellectual property rights. There's so many reasons, but the main reasons are identified on the slide. One, it is your business asset. It has high commercial value. And we have heard of many companies with, brand values of billions, right? Let's talk about companies like Google, like Airbnb. These are some of the companies with high commercial value because of their intellectual property assets, not because of their physical or fixed assets, right? Intellectual property rights also establish your rights and ownership. Just like a house, you would have a title, to the house. So by protecting your intellectual properties, you will be given a certificate to declare or to state that you own this particular brand or particular invention. By virtue of that, it gives you competitive advantage over your competitors or over other companies trading in the same trade or industries. And it gives you the freedom to operate. And with your intellectual property rights, it is an incentive for a company to attract investors and funding to invest in your company. And at times, more often than not, it will provide you with defenses against infringement or even threats of infringement. And of course, as any company, you will invest in R&D. So by protecting your intellectual property rights, it provides return on investment. It generates revenues. It provides income streams to your company. And of course, it provides protection to your innovative ideas and R&D. So some of the ways that you can actually monetize your intellectual property rights. One very common way is for the owner of the IP rights to use intellectual property rights themselves to commercialize the intellectual property rights. For example, if you have a shoe business, you can actually use your brand. For example, Nike started with shoes, right? And then it uses the brand value of Nike to expand to other areas, to clothes, and then now to activewear like yoga wear, right? You can actually use it as to license third parties or to franchise third party to use your intellectual property rights, your brands. For example, McDonald's, Malaysia, we know T-Life, Mary Brown, they're into franchising. The brand is associated, customers' recognition is there. And of course, you can use it for merchandise your products. And Hello Kitty is one of the many success stories of a successful merchandising company. It's a multi-billion company. It has products ranging from toilet roll to being used in a hospital, to aeroplanes, bearing Hello Kitty marks, right? And you can sell your intellectual property rights, whether you want to sell it on a country basis, right? Or basically maybe a certain part of your business. And if you sell it, you may even get, to use it by getting some licensing back. So in a sense, intellectual property is a very scalable way to actually use your rights. You can enter into collaboration, strategic alliances, and you can have a coexistence arrangement with some brands. You can get financing, as I mentioned earlier, and some of the ways that you can actually get settlement, damages, or recovery. And one interesting example that an intellectual property owner can do, where physical properties may not be able to do, is they can actually scale in such a way, very creative way. If you look at Adobe, they started by providing products that are free. And now, once you're hooked on it, then you may actually buy the products, or you will subscribe, pay for their products for other, premium upgrades, right? So these are some examples of how you could actually monetize your IP. And let's focus on just a few main types of intellectual property rights, which are quite commonly used for or commonly created or developed by SMEs. Trademarks, which are very, very important, your brands that will identify you as a source of origin of your products or services. Copyright is a form of a protection for your expression. It protects firms, it protects your software, it protects your annual report, and even the PowerPoint slide like what you're seeing right now. And industrial designs basically protect the shape, the aesthetic visual appearances, you know. And if you're talking about like a Heineken cube bottle, right? Is, you know, or chairs, and chairs that are not that do not have 4 legs, right? Or even mooncakes. For those of us in Asia, we know that, you know, when mooncake festivals, the attractiveness of the products are no longer just of the mooncakes, but the packaging that the mooncakes come with, right? And if we move on to trade secrets and know-how, in Malaysia, it will be protected as confidential information. It can protect your profit margin. It can protect your secret formulation. It can protect your marketing ideas that are not publicly known. Of course, we heard of WD-40, where the formulation is being protected for many, many years, or Coca-Cola secret recipe. Last but not least, we talked about patent, which are inventions or novel ideas in providing solutions or new way of doing things. And in Malaysia, if you're very, you know, if you like half-boiled eggs, we have a very famous invention. You know, if you look at the picture there, is a orangey color. Is, you know, apparently the patent has expired, but you know, if you like half-boiled, it's made to perfection. Best way of making your half-boiled egg. So these are some examples of the main types of intellectual property. And what are the applicable laws? And in Malaysia, generally, we do have a statutory regime for each respective intellectual property rights. Let's start with trademark. For trademark, we have a Trademarks Act 2019, which means you need to file your trademark in order to get protection under the legislation. But as a common law country, we do protect common law rights in the sense that if you use your mark in Malaysia and you haven't registered it with Malaysian IP office, you could actually rely on your common law rights to take action against the party for passing off, known as unfair competition in certain jurisdictions. This is trademark laws is basically to protect signs which identifies a particular source of origin. And it distinguishes one company from another in terms of their products or services. And we have a Copyright Act in Malaysia that protects recorded expression of ideas in the form of various works. That includes literary, artistic, musical works, film, sound recording, broadcasts. And as long as sufficient efforts and they are original and they're recorded, they can be actually protected, and if they are qualified for protection. Whilst we have a recordation system, it's not compulsory. By virtue of Berne Convention, copyright arises automatically in these works. Moving on to industrial designs, as we shared earlier, the examples of various types of products where it's very appealing in terms of the eye appearance, appeal to and judged solely by the eye. As long as the designs are new in Malaysia and elsewhere, and they're not dictated solely by function, they can actually be registered under the Industrial Designs Act. And we have confidential information. Confidential information is not a registrable right in Malaysia. So there is no specific legislation that enable you to register the confidential information. But it can be protected, one, by way of contract. So you can enter into a non-disclosure agreement, or you can actually protect it by keeping it secret and confidential. Okay? And for patents, it's very important that you file the patent before you disclose the confidential information or about your invention, because if you disclose it to the public, it can actually destroy the novelty, right? So it covers or it protects new, inventive, and industrially applicable products or services. So these are the applicable laws in Malaysia. And basically, given the time constraint, we'll not go into detail about how to protect. What's important to note is, for certain IP rights where, you need to prove newness or you need to prove novelty, it is important that you do not actually disclose or sell the products before you file the applications with Malaysian IP office. So it is very important for you to file the application first before you commercialize or before you share the information with the public, right? So this applies to industrial design, this applies to patent, right? As for trademarks, while if there's no such requirement, of course, it is very important for you to file first before someone else files it before you, because that will block your application. So it's very important to file your application because the examiner will assess it on a first come, first serve, first file basis, right? But of course, like I mentioned earlier, in Malaysia, we have common law rights. And even if you don't file your trademarks in Malaysia, you're still able to sue for passing off as long as you prove certain requirements. The requirements is there must be use of the marks in Malaysia, right? There must be reputation, there must be goodwill. And how do you prove that? You show by adducing your evidence of sales records, your revenues, your advertising and promotional materials. So it's very important for a company to keep proper records. So these are basically the key pointers if you want to protect your trademarks or your IP rights in Malaysia. As for confidential information, it is very important before you disclose any information to your business partner to have an NDA, a non-disclosure agreement in place, and to ensure that your employees do not breach any of the information that they received whilst in their employment. There should be confidentiality clauses in the employment contracts. And you should also restrict access to the records. So just to lighten the depth of the discussions, I have a case study. This is a fictitious case study, of course. Well, Sardine restaurants in Berhad is one of the successful farm-to-table restaurants in Malaysia. The trading name is Sardine by Bayam. So Sardine's flamboyant chef and owner is called Bayam. He is touted to be one of the top and upcoming chefs to watch out for in Asia. So Sardine has been in operation in Malaysia for the past 10 years. He has registered the trademark Sardine in class 43, which is for restaurant services. And he does own a domain name, sardinemalaysia.my in Malaysia only. So its menu is simple yet classy, offering a selection of local cuisine, carefully selected and created mainly from locally grown or raised animals, vegetables, herbs, and fruits. So its specialties and signature dishes include banana hard salad, nasi ulam is a kind of herb rice, durian pancake for those who like durian, the king of fruits in Malaysia, and starfruit mousse. These recipes are Bayam's street secrets. So Bayam has been approached by a self-proclaimed renowned food critic and his acquaintance, Lala, who is based in Italy, who would like to franchise his restaurant concept to various parts of the world. So Lala told Bayam, trust me, I will make Sardine a household name like KFC and make you tons of money. Please share your secret recipes with me and I'll file trademarks for you in my name to save you a lot of trouble. So Bayam is very excited about this potential successful venture and the opportunity to make a lot of money, and he has contacted his friend for advice. So some of the issues that, if we can actually pick up, so the starting point is, well, I'm sure we all have friends who can offer us a lot of free advice. So it's very important because the topic in question is very niche and specialized. So unless the friend is a lawyer and has experience and expertise in the relevant fields, it is, of course, advisable that Bayam should seek advice from an IP expert, or get help from Southeast Asia SME Helpdesk. So before, while Lulu, may have good intention, Lala may have good intention to help Bayam, the important part is, we always should err on the side of caution because it's merely an acquaintance. And even if Lala is Bayam's friend, it's very important to make sure that this is a business transaction. So before you share all your important information, you should sign an NDA first, perhaps, right? You should also conduct due diligence of your potential business partner. You should ask for the relevant information, documentation from your business partner. And you can actually seek help, from the council from other countries, especially in the countries where Lala intends to market, or expand the business for Bayam. And before you appoint Lala or you enter into a transaction with Lala, it's very important to protect your intellectual property rights, for Bayam to protect his intellectual property rights in the relevant markets. Why? Because even if Bayam has registered the trademark in Malaysia, the rights in Malaysia are limited to Malaysia because intellectual property rights are generally territorial by nature. So a trademark registered in Malaysia will not automatically be protected, let's say, in Italy, in EU, or in other countries, right? So it's very important for Bayam to consider the markets and also to protect the rights. So the question then is, should Bayam allow Lala to file the trademark in his name, right? So would you allow someone to register the property, your house, in their name? So the answer is very simple. No, you wouldn't do that, right? So even if Lala has good intention to help Bayam, it is not advisable to allow someone else, to file the IP rights in their name on your behalf, right? And last but not least, you should enter into the appropriate agreements, and the agreement should set out what are the obligations, who owns the right, and what happens if the arrangement does not, it falls through, right? So the exit clauses or termination clauses. So these are some key points of the study. Moving along, I'm just coming towards a few last slides. So some practical tips to share with the participants. So for trademarks, it is very important and advisable to conduct clearance searches prior to filing and using in order to provide any potential refusal or threat of infringement or even infringement. So one lesson learned from Burger King is that, if you go to Australia, you can't find Burger King because they are not able to register Burger King in Australia. When they wanted to register the word Burger Kings, apparently it has been registered in Australia. So they have to adapt and register the mark Hungry Jack's instead. So in order to avoid this awkward situation where you have one country where you have to use a different brand name, so it's very important for you to actually protect your rights immediately. And of course, when you protect your rights, you make sure that you identify the appropriate classes, because in most countries, there are 45 classes of goods and services. Your rights and scope of protection would depend on the classes as well as the descriptions of goods and services. And if you don't use the mark yourself, it's very important to ensure that you have a recordal, with the IP offices, and to ensure that the agreements cover that all use by your licensee will accrue back to you. As for copyright, whilst there's no copyright in ideas, procedures, or method of operation, just bear in mind your trademark logo may enjoy copyright protection. For example, the WWF Panda, apart from the trademark right, it actually enjoys copyright protection for the Panda logo. Same with the Timberland 3 device. And for works created by third-party agency, it is important to keep records of the payments that you made and to make sure that there is no arrangement that all rights belong to your ad agency. So in Malaysia, there's a presumption of copyright ownership in the client, meaning that if you commission a third party to do your creative work for you, you own the rights, unless you agreed to the contrary with the ad agency. And make sure you keep records of the authorship of works, because the duration of copyright protection of artistic work, literary work, depends on the life of the author, right? Unlike a work like sound recording or film, where it depends, on the date of the publication. So for confidential information, it is very important to mark your documents confidential, private, and confidential, or is covered by a non-disclosure agreement. So make sure that you sign a non-disclosure agreement with your business partners prior to disclosure, and adopt proper office management and policy, as well as to communicate such policies to your employees, to your business partners and vendors. It is also important to develop security and access policies about how to keep the information confidential, the password, registration. Of course, if you have any logbook to ensure that the access is properly recorded. So it is also important to periodically train, educate, and monitor your employees. And likewise, if you were to engage a competitor's employee, you want to make sure that the employees do not disclose your competitor's confidential information to you, because as a third party adopter of such confidential information, action may be taken against you. So for patents, some practical tips include keeping invention confidential before filing, and to make sure that you identify the existing inventions or prior arts before you invest money in filing worldwide and expending a lot of resources. It is also important for not only for patent, for all your IP rights, to maintain accurate and detailed records of the development process, so that it becomes very useful in the event of legal disputes or challenges to your patents or to your trademarks and all that. So lastly, even if you don't remember a lot of the topics I've covered, so some key takeaways: intellectual property rights, they are valuable commercial assets. IP is territorial in nature, so what is registered or protected in other countries will not automatically be protected in Malaysia. You may want to consider, Malaysia has become a member of Madrid Protocol since 2019. We have been a member of PCT for many years. You may want to consider protecting through this kind of international registration. So it is important to secure filing first before you disclose or commercialize your product spaces. It's always important to conduct due diligence or clearance searches to avoid potential conflicts. And finally, whilst you may think protection is expensive, but failure to do so has serious consequences. So these are the two poll questions. So I think Nora will organize this for
yes, you already see it on the screen. So for the participants, so the first question is: trade secrets are protected by formal registration with Malaysia IP office in Malaysia. Is it true, false, or I don't know? The second question is: it is advisable to keep your invention confidential and not disclose it publicly before filing a patent application. Is it true, false, I don't know? So we would give you around 20 seconds to share your opinion. Don't worry, there is no punishment in case of wrong answer. And then Jenny will comment on the result. So let's wait a few seconds and then you will see the result.
Yeah, thank you, Nora, for the poll, for sharing the poll questions. Well, unfortunately, there's no prize either.
True. So for the first question, you see the result. Everyone said false, and for the second one, everyone said true.
I think we have a very good student in our webinar. but well done. At least you paid attention to my presentation. Thank you so much, Nora. And thank you so much, everyone, for for your patience in listening to my presentation. I'll be happy to take any questions during the Q&A session.
Yes, thank you very much, Ginny, for the presentation. It's IP is a very important topic, and I'm glad that during today's webinar we matched the business and how to do business in Malaysia and how to integrate an IP strategy as part of your business plan. So that's very good. Just a quick comment from my side. So these are 3 publications we wanted to share with you because we think that those who joined today's webinar might be interested. So we have a guide on how to internationally protect your trademark through the Madrid system. Another one on how to have a patent internationally. So it's the Patent Cooperation Treaty. And we have an IP fact sheet on Malaysia. So we encourage you to check those publications on our website. We put the link as well, so it will be easy for you to access. And then, well, this is just a little bit of promotional from the project side. So if you have any IP questions in the future, we have an email address at SEA IP Helpdesk.eu. So we will reply within 3 working days to any IP question, and you're always welcome to subscribe to our newsletters to follow our news and be updated about upcoming activities. And then I think we can move to the Q&A session. So you can still send any questions you may have to our speakers today, so we can answer them live. There is one question from Jenny that I already see. So there is a company with a water purifier product, and they are planning to enter Malaysia next year. And they filed a patent application through EU IPO in November 2022. The question is, can they still claim priority for this patent in Malaysia? And if yes, then what would be the way? And they have a second question: if they want to register their trademark in Malaysia, which class is suitable for the application? So if you have some thoughts related to this question, please let us know.
Yeah, thank you. It's a very good question. Of course, in Malaysia, we are a member of Paris Convention. You can still claim priority within 1 year from your filing date. So you have until November 2023. So that is for the patent question. For the trademark question, purifiers are classified in class 11. That is for the products. But if you have, if you want to have a stronger protection or wider protection, you may even file for class 35 for the sale of the products. So that may be another consideration. So class 11 and or 35. So, that will stop people from selling, your products.
Okay, thank you very much for the clear answer. For Antonio, I would like to ask if a company is planning to set up a business in Malaysia, is constitution is mandatory? And also maybe you can add if an annual general meeting would be mandatory.
Well, since the approval of the New Companies Act of 2016, the constitution of the company, which is another word for the memorandum and articles of association, is not mandatory. Of course, company may have one on the point of incorporation or later on. And with regard to the AGM, if we're looking at a private company, the AGM is not mandatory. For public companies, yes, it's always mandatory, but not for private companies. It's good housekeeping, obviously, I would not say otherwise. But again, with the new provisions in the Companies Act 2016, it is not necessary.
Okay. Thank you very much. For Ginny, I have one more question for you. This is something that actually we often get asked from companies, from EU SMEs, when they have a trademark already registered in the EU. They ask if it's automatically valid in Malaysia, or there is anything additional that they need to to do in order to make sure that their brand is protected in Malaysia?
Thanks, Nora. Yes, I understand it's a very common question. No, the registration in EU or under the CTM will not extend automatically to Malaysia. So the owner of the mark should consider filing in Malaysia before they actually expand into Malaysia. And they can actually file through Madrid Protocol, or they can file directly as a national application, in Malaysia.
Okay, yes, thank you. And just before I mentioned that we have a guide on the Madrid system, I honestly discourage everyone here to check out that guide, because if you are doing business internationally and you want to protect your trademark in different countries, then this guide can give you a good guidelines how to go about it. Maybe we have still one more time for a question for Antonio. Is it possible for a foreigner to be appointed as a company director in Malaysia?
Yes, it is possible. We just need to be sure that the potential foreign director has residency papers. So we looked earlier at the employment pass. There are also temporary employment passes and multiple visit passes. So obviously each one serves a different function. Nevertheless, in short, yes, it is possible. Again, with a valid employment pass, and that employment pass is also linked to the paid up capital in the company, as we saw during the presentation. Okay,
wonderful. I would like to thank you to our speakers today for the great presentations. You all managed very well the time, and the content was interesting and straight to the point. So I'm sure that this was very practical information from companies who wanted to learn more about this topic. And we also recorded this session, so we will upload it to our website, and we will send a follow-up email to all of you who registered and also those who attended with the information, so you can always access this material for future reference. And thank you for our participants for being with us today. Have a nice afternoon or a nice lunchtime soon. Bye.
Thank you.
Bye-bye.